Good afternoon, everyone. Thank you for coming to today's seminar. We're pleased to welcome back our good friend, Professor Kumaralingam, Amirthalingam. I think you probably doesn't mind being called Kumar, who is from the National University of Singapore. I think the last time you were here, you were talking about court law, one of your loves, and today you're talking about your other love of prosecutors. Well, criminal law and prosecution. And I know, Kumar, that of course you're not just a scholar in the ivory tower, that you have also had experience working in the Attorney General's office in Singapore as their Senior Director of Research and Policy in the prosecutions area. And today you're here to tell us about an ongoing project that you have looking at the public prosecutor and the rule of law. Thank you for coming.
Thank you. Thank you very much, Simon, and thank you. Okay, let's try that again. Thank you very much, Simon, and thank you all of you for coming along. I know is this marking period? Because this marking period for us.
No, not yet.
No,
exams. It's actually a good period.
Oh, it's a good period.
Oh,
great. Well, thank you anyway for taking the time to come out here. So this is, as Simon has said, it's a repeat visit. I've been here a couple of times and I love coming out here. The last time when I came here, I gave a paper on tort law, which I have written up and I'm in the process of submitting. So I see this is a good omen. So this is, again, another place where I want to launch ideas, get some feedback. So this is a topic that I've been working on now for the last 5 years or so. Well, this is the theme, right, on public prosecutions. And I've written a couple of articles, and this is going to be another one in that line of articles. So let me maybe just start off with this quote here. So this was actually at a time when I was at the Attorney General's chambers, 2012 to 2014, on secondment, and we were at the International Association of Prosecutors annual conference in Moscow, and that's a quote that I've just taken from Dominic Greaves, the then Attorney General of the United Kingdom, and I'd like to use that to start my discussion because it really contains some of the core themes. So he talks here about fair adjudication and the rule of law. And just looking at the second paragraph there, a trial where the conclusion is predetermined, dictated by politics, or directed by the government does not uphold the rule of law. It is vital, therefore, that the prosecutor be a fearless defender of independence, impartiality, and fairness, ensuring not just that the guilty are convicted, but also that the innocent remain free. So that's a big responsibility that prosecutors carry. And from my own experience in chambers, I think they try to do their very best, and they do appreciate the ethics of public prosecution. But in terms of the system, I think there are some issues that we need to look at a little more carefully. So Dominic talked about independence, right? And I think that is crucial. The public prosecutor has to be independent, although the public prosecutor is part of the government. And the reason for that is that you don't want the government to be able to use the criminal law as a weapon against individuals. Right? Because the criminal law really is the weapon of the government. You can put people behind bars. In some countries, you can even end their lives. So it's not something that you want to be used as a tool. And therefore, the public prosecutor should always have independence from the government and should only initiate prosecutions when it is in the public interest. It must act fairly. The flip side of the independence, of course, then becomes a question of accountability, because when you're looking at government, we have to some degree some checks and balances through the separation of powers. So the executive is checked by the legislature and the judiciary. The legislature, if it wants to enact inappropriate laws, can be checked with the executive and the judiciary. The judiciary, in a sense, is the check of last resort. Who checks the judiciary? Well, the democratic process, ultimately. But also the judiciary doesn't wield power, so we don't have to worry too much about that, except when the judiciary becomes too activist, but that's a whole separate discussion to have. So those are some of the questions that I want to pick up on today. I'll also mention briefly the idea of the rule of law, but this is not intended to be a rule of law paper. That's a huge area. But I want to just try and distill out what what I mean when I talk about rule of law concerns with respect to the public prosecutor. And then the third theme is this idea of discretion, and how does discretion fit in with the rule of law. Okay, this is just to give some context to the Singaporean position. So what I'm saying today, I think, would have general application to most jurisdictions, but of course I'm speaking from the perspective of a jurisdiction that I understand best. And just from my own experience and my own research, you can, just looking at that slide there, you can see that the public prosecutor has a role to play at many stages, right? So the most obvious is in the conduct of prosecutions, with the charging, initiation, termination of prosecution, and so on. But the prosecutor also does a lot of things outside prosecution. So we have diversionary programs. I think in Hong Kong we also have, to an extent. Not enough. Okay. So in Singapore we have a pretty active diversionary program scheme. So what happens here is that instead of charging, the prosecutor will issue a warning and then put the person on a diversionary scheme. So typically 6 months, 12 months. Sometimes that's conditional, so if you don't serve your whatever the diversion requirements are, whether it's education or training or psychiatric care, then the prosecution can come up again. Now, this is done outside the court system. So the prosecutor, in a sense, is acting as an adjudicator, right? And that's going on. In Singapore, we also have detention without trial. I'm sure you're all familiar with that. I'm not just talking about the Internal Security Act, but also the Criminal Law Temporary Provisions Act. So we have the Criminal Law Temporary Provisions Act, which empowers the minister to make orders to detain a person without prosecution, where there is the public safety that's being threatened. But that has to be with the consent of the public prosecutor. Then more recently, and I think I've talked about this also here in Hong Kong in one of my visits, Singapore moved a little bit away from the mandatory death penalty for murder and for drug trafficking, and that provision there, Misuse of Drugs Act, they introduced a regime of a discretionary death penalty under certain conditions, one of which is when the public prosecutor issues a certificate of substantive assistance. So if the public prosecutor issues the certificate, then the offender who would otherwise face the mandatory death penalty may be sentenced to life instead of death. Okay. Now that issuance of a certificate is solely at the discretion of the public prosecutor, and it is very difficult to challenge. There have been a number of challenges that have been going through the courts, and there's a big one coming up early part of next year to test whether that provision and the ouster provision is valid or not. Okay, but so far the courts have said it's all valid. And then finally, in terms of clemency, so the president has the power of clemency, he can commute the death penalty. But again, that is done in a sense on the advice of the Attorney General, who in Singapore is the public prosecutor. Okay, so the public prosecutor has a lot of power in Singapore context. So let's talk a little bit about the rule of law. So the rule of law, I think you'll appreciate, is an essentially contested subject. Right? It's something that most people really can't agree on. Everybody agrees that it's a good thing, but exactly what it is, people disagree on. And if you just look at the literature and you look at how it is discussed, you can see there are a number of functions that it plays. Principally, and this is the conception of rule of law that I'm most attracted by, is that it protects individuals against the arbitrary power of the state. And I think that really is the origins of this idea of the rule of law. But it has also developed into an instrument to facilitate social and economic development. You see quite a lot of literature on that. And then, interestingly, you see some state organs talking about rule of law to actually defend quite robust criminal laws and security laws. And you see that particularly now in the post 9/11 era, where they talk about rule of law demands that we have very intrusive surveillance and robust prosecution because we have to protect individuals against these threats. So what is this rule of law? Is it a deontological concept or is it an instrumental concept? We see in the literature the difference between the thick and the thin, rule of law, rule by law. Sometimes, particularly I think when you look at the narratives in Singapore and Malaysia, it's more of a rule of law and order. That's why when the governments talk about it, they say, well, we need to have rule of law, by which they mean rule of law and order and safety, and that's why we have these robust laws. Okay, so again, you can see here the differences. I don't want to go through this and belabor the point, but you can see that there's a right wing, left wing, and a centrist view of the rule of law, which comports with some of those categorizations earlier. So let me just come quickly now to this idea of rule of law, which I think is particularly germane to public prosecutors. And so I take this from Lord Bingham's definition in a book that he published almost a decade ago, I think, now, giving a definition of the rule of law and then various ingredients of the rule of law. One of which he highlights is that matters should be decided according to law and not normally by discretion. But as we know, the criminal justice system involves a lot of discretion, not just at the prosecutorial level, but right from investigations and so on, and I just mentioned that later. So how does that fit in how does discretion fit in with the rule of law? Is a question here. Then just moving on again very quickly to Jeffrey Giles' view of rule of law. So he distills from Bingham's 8 ingredients 4 key aspects: legality, legal certainty, equality, and access to justice and rights. Again, he says, and again, this is something that appeals to me, he says, in fact, it could be said that the most important defining feature of a state based upon the rule of law is that a person in a rule of law state has the opportunity of challenging the government of the day with a reasonable prospect of success in an appropriate case. Now, if you use that as, in a sense, a yardstick or a benchmark, then that raises questions about how the prosecutor's power comports with the rule of law. Because you may or may not know, it is very, very difficult to challenge prosecutorial decisions. In Singapore, the prosecutorial discretion is enshrined in the Constitution, and the grounds for judicial review or challenge are very, very narrow. And there's not been a single case where there has been a successful challenge. And that's also similar, I think, in Hong Kong and even in the United Kingdom, although in the United Kingdom things have changed and there are slightly broader grounds for review and challenge of prosecutorial decisions. Okay, so I just also wanted to dispel any idea that discretion is just people acting on the whim or on personal choice. No, discretion is an integral part of running any system, because you do need to be able to contextualize your decisions to particular facts, right? And therefore you do need to have some discretion in deciding whether to prosecute, what charge to pick, and so on and so forth. Okay, so discretion is a necessary part of any criminal justice system. Now, excuse me. So again, when you look at the criminal justice system, right, the discretion doesn't exist only at the level of the prosecution. It's there right from the beginning, even before it enters the legal system. If you think about it, you know, the criminal justice system is generally only engaged if a victim makes a complaint, and there's an exercise of discretion there. Some victims complain, some victims don't complain, right? So things may go into the system or not go into the system simply based on somebody's decision. Once a complaint is made and the criminal justice system is engaged, it starts with the investigation, and the police have a lot of discretion as to what cases they pursue, how they continue their investigations, when they terminate their investigations, and the kind of report that they then send on to the public prosecutor's office. Once it comes to the public prosecutor's desk, then the public prosecutor has discretion. What do you do with this? Do you order further investigations? Do you decide to charge? Do you decide to take no further action? Do you decide to warn? Do you decide to divert? So there's a whole lot of choices here that the public prosecutor has, right? And that's the discretion here. Then once it goes through and it ends up in a conviction, if it ends up in a conviction, the sentencing, again, is a matter of discretion. It curtails to an extent, but largely it's a matter of discretion. And then finally, as I said, clemency, again, is a matter of discretion. So discretion is woven through the criminal justice system all the way It's a necessary part, but it raises some difficulties as to how it is used, how it is controlled, and where the accountability comes in. So that's all kind of like the background stuff to my talk. So let me get into some of the slightly more challenging parts of it. So first of all, when we look at prosecutorial discretion and the rule of law, I distinguish between what I call the vertical relationship and horizontal relationships. Okay, in terms of the vertical relationship, you want to have we're talking about the state and the individual. Okay, so this is going back to the classic idea of rule of law. It's a constraint against arbitrary power of the state. So here you're looking at prosecutorial powers and rule of law, and you're looking at it in a constraint model. You want to control the power of the public prosecutor. You want to control the power of the public prosecutor, but the public prosecutor is acting as an agent of the state. Then when you look at the horizontal relationship, they're talking about it between individuals. Now here you want to empower the public prosecutor, because here you want the public prosecutor to have the power to come in and prosecute wrongdoers, to protect the victims or the innocent parties, or to preserve law and order. So there is this constraint empowerment paradox here that is going on. The need for independence, I think I've already mentioned earlier, right? Why we need the independence. Now the question is, how do we have proper accountability? How do we have proper accountability? Okay, let me also just set out a little bit here, because I'm not sure how many of is everyone familiar with how prosecutorial discretion works? How prosecutors exercise discretion? Is anyone not?
I'm a layman, I don't.
Okay, so basically it's a two-stage test, right? First of all, there's an evidential sufficiency test. So the prosecutor has to be satisfied that there is sufficient evidence before charging. Now, if there is not sufficient evidence to give a reasonable prospect for a conviction, then the prosecution should not take place, right? It simply should not take place. If there is sufficient evidence for a reasonable prospect of a conviction, then, as a general rule, the prosecution should take place because a crime has been committed. But even then, there is a second question, which is, would it be in the public interest for a prosecution to take place? Okay, so here the public prosecutor will take into account any number of factors. Sometimes it can be simple, very, very bland factors. You know, say the first-time offender, is it a low-value item, is it necessary to use resources? Sometimes it can be much more sensitive questions. Will a prosecution here endanger national security? And there are cases there. Right? Now, how do you deal with that? To what extent then should the public prosecutor be talking with the executive or the legislature? Is there any risk here that there could be improper influence? Okay, so that's basically the way the public prosecutor exercises the discretion. Now, can the decision of the public prosecutor or the prosecution be challenged or be subject to judicial review? Yes, it can, because there should be no power that is completely unfettered. But the scope for review of prosecutorial decisions is very, very narrow. In Singapore, it's limited to abuse of power, basically. So because the prosecutorial power is enshrined in the Constitution, it's restricted to abuse of power by the public prosecutor or breach of constitutional rights. And so we've had a few of these constitutional right challenges, basically trying to engage Article 12, which is the equality provision. So there have been cases where, for example, the public prosecutor has charged two accused persons, both involved in the same crime, most of them drug trafficking crimes, and the public prosecutor charges one person with trafficking in a quantity of drugs that triggers the death penalty, and then the other accused person with a quantity of drugs just below the death penalty. Right? So the question is, can you do that? Because both these people have been engaged in exactly the same crime. They both traffic in exactly the same quantity of drugs. Let's say it is 500 grams of diamorphine. Right? In Singapore, if it's 15 grams and above, then the death penalty is triggered. And there are many cases where the public prosecutor would charge accused A with trafficking in maybe 74 grams of dimorphin, okay, once it's cut and dried and weighed, and then prosecute the charge accused B with trafficking in not less than 14.99 grams. Okay, now that is entirely within the discretion of the public prosecutor, and there have been many challenges, and the courts have said no, it's perfectly valid. It is not a violation of Article 12, because Article 12 only requires that everybody be treated equally. But where there are unequal factors, then the result can be unequal treatment, but it is still not in violation of the equality provision. Okay, because there are many other factors that may distinguish accused A and accused B. Now that, in a sense, now has been that need, that kind of charging decisions has been reduced, because we now have the discretionary death penalty, and the prosecutor can issue the certificate of substantive assistance, right, to get around that. But we still have both these systems running in parallel. So that's in Singapore. In the UK, it's a slightly broader ground for judicial review, still similar in terms of bad faith, dishonesty, basically looking at abuse of the process. But in the UK, they have published guidelines, and the law requires the prosecutor to apply the guidelines. So if there is a breach of the guidelines, that's a ground for review. Okay, and that has created some difficulties. So you've had people challenging prosecutorial decision to charge, or in some cases not to charge. The victims want to complain, and because of that, so the courts have said, look, where the prosecutor has charged somebody, there's really no pressing need for that person to have a right for judicial review, because that person's case is going to come before the criminal court, and if the charge was improperly laid, then the criminal court will deal with it, right? So he or she will get justice through the criminal process. But where a victim says a prosecution should have taken place, but the prosecutor refuses to charge, then that person has no recourse to justice. And so the courts have said, well, maybe here there is a stronger need for some sort of recourse and judicial review. And so England then in 2011 or 2013, I think, came up with this victim's right of review. Okay, so it sets out grounds when the victim may have a right to seek a review. That's still an internal process, so they can apply to the CPS, the Crown Prosecution Service, to seek a review of the earlier decision by another set of prosecutors. So that's limited only to situations where there's no charge at all that is preferred, or where a charge is preferred but the prosecution is discontinued, or where the prosecution refuses to offer any evidence against an accused person with respect to the aggrieved victim, or they just let the charges lie. And then there are a whole lot of disqualifying reasons as well. And now there are a number of cases going through the UK courts that arising out of the victim's right of review. So what's happening is that the victims seek the right of review. It goes to another group within the CPS. They affirm the earlier decision. The victims then go for judicial review of that. Those cases are coming through the courts. A couple of them have also hit the UK Supreme Court. So I'm looking at that as a separate project just to see where that is going. Okay. So a couple of things here just again to highlight. The courts continue to reiterate that they do not have a role to second guess the prosecutor. Okay, the courts cannot second guess the public prosecutor. So these are just a couple of cases, recent cases. One from the UK Court of Appeal, which involved an abuse of process, a stay of prosecutions. And the Court of Appeal held that the trial judge was wrong to interfere with the prosecutorial discretion. They said that, look, as long as the prosecutor's decision was taken in good faith, even if you disagree with it, you cannot interfere. That is a call for the prosecutor to make. You then just have to hear the case. So you can see that the prosecutor's powers are very, very strong. Now, that to me is a good thing, and I was and still am a proponent of that, because I think it is vital that the public prosecutor be independent of the government, right, for very, very obvious reasons. What this project that I'm now trying to work on and develop or think about is whether there is a risk that by championing this independence of the prosecutor and taking this very hands-off approach to the judiciary itself is doing, is whether we are inadvertently creating a black hole, right? A black hole where there's no review, and which, in a sense, may be valuable to the executive or the legislature for tactical reasons. So this is paradoxical in a way. Right? So I can give a couple of examples. The two themes here. One is in terms of when it comes to national security. Right? There is an advantage here to have prosecutorial discretion shielded from judicial review, so you do not have to reveal sensitive information, and the executive likes that because they can hide, in a sense, hide behind this prosecutorial discretion. So in the Corner House case that didn't involve the CPF, but it involved the Serious Fraud Office, and there was an investigation into an arms deal between the UK and Saudi Arabia companies. And I think they discovered there's some fraud that was taking place, and they were investigating these companies, including the Saudi Arabian connections. And then the Saudi Arabians basically told the UK government, if this investigation continues, we are going to pull out from a lot of our joint counterterrorism initiatives and so on. Now, the director of the Serious Fraud Office, then in consultation with government, decided to stop the investigation and stop the prosecution. A review process was launched by the complainant and succeeded at the trial level. Right? They said no, the trial court said no, the director shouldn't have caved into this kind of political pressure. They should carry on their work independently and administer the criminal law. It went up to the House of Lords, and the House of Lords basically said no. This was within the discretion of the director of the Serious Fraud Office. You can draw same parallels with the director of Public Prosecutions. And the only question that the court should be concerned about is whether or not this was within the proper ambit of the discretion. It is not the business of the court to go beyond that to ask whether this was a proper decision or a correct decision. That is within the discretion of the Public Prosecutor. And they also accepted that, look, when it comes to national security, the executive has to make certain choices, and the judiciary shouldn't interfere. There was another decision which I'm not talking about today, which came through the victims' rights process, a UK Supreme Court decision called Belhaj. Some of you may be familiar with this. That involved some detainees who were basically caught up in this whole terrorist thing and were, I think, under the rendition protocols, taken to Malaysia or somewhere else. And they then alleged that a British intelligence officer was responsible for that and wanted him to be prosecuted. The CPS investigated and then decided not to prosecute that person. So this then went on a challenge. And basically, it came up on a separate point on whether or not there should be a closed materials hearing. But there was dicta in there to say that no, this is something where there is national security involved, there is intelligence involved, and it is within the discretion of. So that's an English example. From Singapore, we see this in the misuse of drugs case, right? I've talked about this before, and I've just mentioned it earlier. So the prosecutor has discretion whether or not to issue a certificate of substantive assistance. He doesn't have to disclose reasons for it. He doesn't have to explain. He doesn't have to even say what information he relied on or why he has chosen not to issue the certificate. The courts have said that that is entirely acceptable. Okay? And the reason given by the government and then accepted and endorsed by the courts is that the Attorney General and Public Prosecutor is acting on intelligence that should not be shared with the public, because it will compromise national security. Okay? I'm also told that some of this intelligence is classified at such a level that even the judges are not cleared to hear it, so how can they anyway be asked to hear this, right? So you have these kinds of cases here where the public prosecutor's discretion is in a sense clothing a lot of national security matters, and we can't penetrate into that. Okay, so the question is, how far can we go? I mean, when we look at these cases, maybe we can say this is still on the right side of the fence, right? But can it creep into the wrong side of the fence? That's one question that I want to explore. Then the second thing in terms of this black hole theory is in terms of how it actually might suit the legislature, which wants to keep morally contentious criminal laws. And again, there are examples from the UK and Singapore. So in the UK, some of you may recall the Pretty and Purdy litigation from the early 2000s. So this involved the assisted suicide cases. In England, although suicide was no longer a crime, assisting or abetting a suicide remained a crime. But there were other jurisdictions in Europe where assisted suicide was not a crime. And so there were some people who wanted to travel to these jurisdictions so that their loved ones could help them end their lives, because they were not in a position to do it because of their physical condition. The problem, of course, is that anybody who helps a person to go and do that is, in England, committing the crime of assisting or abetting a suicide, which is a crime. And so there were cases that went up where the applicants were asking the Director of Public Prosecutions to state at the outset whether or not, if this happened, they would prosecute. Would they exercise the discretion to prosecute or not to prosecute? So in the first case that went up, the Pretty case, the public prosecutor said, no, we can't give these kinds of guarantees, because the discretion is meant to be exercised on an ad hoc basis, right? And so that was where the situation was. The next case that went up, the Purdy case, in that case, the court actually instructed the public prosecutor to issue guidelines, okay, because then it became a question of human rights, all right? Because the European Convention, the Human Rights Act, there was an expectation, right to privacy, and so on, and the court said, look, if somebody is going to do this, then they have a legitimate expectation to know whether or not they will be prosecuted. Now, the Director of Public Prosecutions, of course, argued against that, saying that this would be incorrect. But in any case, they had already issued some interim guidelines, because in the UK, issuing guidelines is pro forma. And so they decided to issue guidelines on what they would take into account. And then after the Purdy litigation, they then basically formalized those guidelines. Right? Which again, if you go and look at those guidelines, they're not very helpful. This is the usual thing, right? Which is one reason why in Singapore the AG's chambers has decided not to issue guidelines, because they said, look, in most of these cases, they're just motherhood statements, right? Poor person, old person, sick person, kind person, fellow versus remorse, so on and so forth, right? So end of the day, this is all common sense. We're not going to put on anything beyond that. So they'd much rather have the guidelines to be internal and secret and much more specific. Now, there are arguments for and against that. But the point is, what you really had was a law that was morally contentious, right? But the legislature didn't have to deal with it, because it could just go in through the discretion. Well, sometimes we prosecute, sometimes we won't prosecute. The same thing is happening now in Singapore. So this has been a long-running saga. In Singapore, we still have the anti-homosexual acts, right? So homosexual acts in Singapore are criminalized, even if it's consensual and in private and so on. Okay, so there have been challenges and they've all failed, so the law remains on the books. Now we've just gone through another round of criminal law, penal code reforms, where 377A was just not touched, but then it blew up again, and then it became a big discussion because the Indian Supreme Court had ruled on section 377, declaring it unconstitutional. So in Singapore, the whole thing came up again and said, well, we should issue another challenge. And then we had some senior members of, not government, but sort of public intellectuals who sort of weighed in and said, yes, we should have another go, and so on. So that was percolating. In the course of all that, you started to have statements coming out from the government and from the Attorney General and former Attorneys General. So this was a strange kind of scenario. Because for a long time, Singapore had maintained this position that they would keep section 377A because some people wanted it. But the government said we will not discriminate against gay people, and so we will not proactively enforce the law. So you see here again, it's, you're trying to have your cake and eat it, and you just basically shove it under the prosecutorial discretion. But it puts the public prosecutor in an invidious position, and it raises, to my mind, to many people's minds, it's not an original thought, serious constitutional questions. Because who made this statement? It was the Prime Minister. Now, can the Prime Minister, or any minister or law minister, come out and say how the prosecutor will exercise his discretion? Okay, so one of the former attorneys general said that was problematic, and he said, no, the discretion should be with the attorney general. So anyway, when all of this was going on, this debate came out again, and so these former statements were brought out. The minister came up and said, no, it will not be enforced, and then the current attorney general also came out and said, no, this will not be enforced. So the question is, who's saying this? Now, at one level, it's if the Attorney General, the public prosecutor, is saying, as a matter of prosecutorial policy, we will not prosecute people for engaging in homosexual acts which are consensual and in private because it is a matter of resource and so on and so forth, then that's perhaps acceptable. But that's a prosecutorial decision. But even if that's the case, it then raises another question, which is, in such a scenario, are we really talking about prosecutorial discretion with respect to charging on individual cases, or are we talking about the public prosecutor who is not a member of the legislature basically rewriting the laws and saying we will not enforce this law? Because still you're talking about a blanket prohibition. Right? This is what the Director of Public Prosecutions in Pretty and Purdy were concerned about. They said, look, we can't come out and give a blanket prohibition. If that's the case, then we're not applying the law. That then flies in the face of the idea of rule of law. Rule of law means you have a law, you have to apply the law, whether you like it or don't like it. Right? So the paper that I'm working on is really this slide here, right? Is there a problem, with this idea of the independence of the prosecutor? Yes, that's great. But then if there's less accountability because we want to protect that independence, and in that black hole we sort of slip in these things, then what are the consequences, right? So let me just end here before we take some questions. So I guess two broad questions. So one is there too much power concentrated in the hands of the public prosecutor, right? I don't know, maybe. That raises the second question as to whether or not there should be a separate office of the public prosecutor from the Attorney General's chambers. This is, of course, germane to Singapore, where the offices are used. Hong Kong, I understand there is the Director of Public Prosecution, but it's not an independent office. Is that correct?
Within the Department of Justice.
So it's within the Department of Justice.
Division.
Okay, so it's a division. So that's still different from the UK, where you have a separate, an independent office of Crown Prosecution Service, okay, which is also the case in Canada and in Australia and in New Zealand, most of the common law jurisdictions that I'm familiar with. It is a separate and independent body. Although in all of these cases, the directors are still supervised by the Attorney General, and in some cases, the Attorney General can intervene. And I think that's necessary, because at the end of the day, the government does have an interest, whether it's national security or public policy. Interestingly, Malaysia, for those of you who follow Singapore and Malaysia, you know that in Malaysia they had a change of government earlier this year, although it seems like ages now, so much has been happening. But some remarkable things have been taking place there. So they have, I think, now said that they will abolish the death penalty in Malaysia. I don't know whether they've already done it or not, but certainly they've announced that they're going to get rid of the death penalty. They've also announced that they're going to separate the Office of Public Prosecutor from the Attorney General's chambers to create the independence. So there are some very interesting things taking place over the straits there. So that's the first big question. The second question then is how do we then balance prosecutorial discretion, independence, within a rule of law framework, right? So these are some of the things that we have to keep in mind. Separation of powers. Although the idea of separation of powers is something that I think we have to approach carefully. I wrote about that in another paper. because sometimes we get infused with American ideas of separation of powers, which are very, very different to our concept of separation of powers, because in the common law system, I think we are anyway much more fused, unlike in America. And of course, if you look across to what's going on right now in America, I mean, it's quite interesting. All of this is tiny little fish compared to a scenario where the president fires attorneys general and interferes with prosecution and so on. So a couple of other things. Then prosecution guidelines are useful, but again, how useful? Prosecutorial ethics, I think, are key, because if you can infuse the right ethical values in your public prosecutors, then that helps. Going back to that first slide of Dominic Reeve. And then this question of judicial review. And it's a difficult one, right? To what extent should you enhance judicial review of prosecutorial decisions? And, you know, that can cut both ways. Okay, having been in there for a little while and just looking at it as an academic, it's really important for accountability reasons, but it can also have potential negative effects. One of which is if the prosecutor decides not to prosecute, and this is one of the concerns that I have with the victims' rights of review, right? If the prosecutor decides not to prosecute because the evidence is not sufficient, and usually that's the case, right? Because if the evidence is sufficient, in most cases the prosecution will take place. Okay, it's only in quite exceptional cases there will be a public interest to say don't prosecute, because generally it's in the public interest to prosecute somebody who has committed a crime, right? So if you're looking at situations where the public prosecutor has decided not to prosecute because of insufficiency of evidence, as is many of these cases, and you allow a review of that and you bring that evidence out in court, that's in a sense unfair on the accused person, right? Because you don't think you can prosecute them and get a conviction, but now you're airing all this anyway in public and sullying their name. So there are some difficulties with that as well. So my own view, I suppose, to put myself out there and take a stand, is that I think that we do need to have perhaps a little more robust judicial review of prosecutorial decisions, just to ensure that there is clear safeguards as to how the prosecutor is exercising his or her powers. Otherwise, there is a danger that it can become something that is threaten the accused. So that's basically the work that I'm doing and the key focus of this current paper that I'm writing. And I would very much welcome your comments and any questions that you may have. I should also mention, and this is, maybe I shouldn't, but I will, because I want to learn a little bit about this. There is, I mean, all of you obviously will know this and maybe quite closely involved with this, with the prosecution now that's going on against the activists. I haven't looked at it closely, but I understand that the charge is for public nuisance or something like that. So here's a question, right, to think about. Are there other offenses with which the accused persons could have been charged? Who makes that call, and what is the motivation behind these decisions, right? So I ask this question not so much in the Hong Kong context, although of course it's directly applicable to the Hong Kong context, but I raise it in the context of the English case that I mentioned earlier, which is this case of R and DS and others. So the facts of that case was that there were a group of people, a large group of people, who basically had a rave in London, a massive party, right? Caused public nuisance and so on. Complaints were made, police investigated, and then they decided to charge. Now, interestingly, they charged these accused persons with conspiracy to commit a public nuisance, which is a common law offense, which carried, I think, more severe sentences than potential statutory offenses that were available, right? And so that decision was challenged, and it went up to the Court of Appeal, and the court dismissed the challenge, holding that it was within the prosecutor's discretion. Now, they also said that, look, they dismissed it on two grounds. One, they disagreed they disagreed that the lesser statutory offences could have been used. Right? So they said, no, in any case, these things couldn't be used, and the public nuisance offence was appropriate. And then they said, but even if the lesser statutory offences could be used, it's up to the prosecution, because they have discretion to decide on the charge. Now, that kind of decisions to be made, particularly when there are political undertones to the action, may raise red flags, right, as to why a prosecutor is choosing a particular offense. We've seen this also in Malaysia. It's like Malaysia is a fascinating jurisdiction now to study, because those of you who know, I don't know if you all are familiar with the history of Malaysia, but you know that the Anwar Ibrahim, who was the leader of the opposition, right, that was trying to topple the Najib government and were unable to do so until Mahathir, who was the former prime minister, came on board, led the group. But Mahathir, when he was prime minister many years ago, had a falling out with Anwar during the Asian financial crisis in 1998, and there were charges brought against Anwar for sodomy and so on, which then put him out of politics for a long time. I make no comment on this, but many people allege that these were politically motivated charges. Now, the two of them are back. Politics is a strange world, but they're now working together. But it clearly raises these questions, right? So what is very interesting, and in a sense reassuring, is that the current government, led by Mahathir, has itself said that, look, we need to hive out the public prosecutor's functions to make it independent of the Attorney General and the government. So I think that's a good development. But all of that does show that there are these risks, right? And we need to guard against these risks. So that's let me stop there and take any questions that you may have.
Okay, thank you. Just on your question about where other offences are available, it reminded me of the Hong Kong case of Mo Yuk Ping, which is a quarterfinal appeal case, charged with conspiracy to defraud. It involves stock market manipulation, price manipulation. And one of the arguments is that there could have been some other statutory offense, less serious, that could have been charged. The quarterfinal appeals response was very much like the English case, a DS response, with one caveat, which is that in Sir Anthony Mason's judgment, he said that if it was shown that the prosecution was going for this common law offense, the more serious offense, in order to deprive the person of a statutory defense,
yes,
that might be abusive, and the court might step in.
Yes. Those points were also made in the DS case. So they did say if there was a statutory defense that was being excluded, or if this was an abuse of process, then yes.
Okay, so we have time for some Q&A or comments. This gentleman at the front here.
Professor, in your definition of rule of law, you chose not to use a fairly common one, which is that of a constrained state. Now, of course, we see that now being clearly open in the US every week, that President Trump is being accused of consistently undermining the rule of law in the US, and the system is robust enough to check his attempted abuse of power. Now, you had a sort of throwaway line, which is to me very important towards the end, that the common law systems were quite different from the US. So maybe you can educate us. Of course, in a parliamentary system, not so much the legal system, that the prime minister has more limited power than the president. But other than that, if a Trump-like figure were to somehow emerge in Australia, Canada, Singapore, how would the system constrain that that kind of prime minister or leader to protect the rule of law?
So in a parliamentary system,
Yeah.
I would assume based on the jurisdictions you mentioned, in a jurisdiction where the courts are fairly robust when it comes to judicial review, how could a Trump-like figure be constrained?
Well, Well, it's very difficult to transpose, right? Because you're talking about a presidential system where the president has veto powers and triple powers, as opposed to a parliamentary system where the head of government is typically the head of the ruling party. So there are already more inherent checks within. And you see this quite often. Well, Australia is the classic example. Right? Whenever the prime minister gets too big for his boots, he gets booted out. So there is that kind of internal check. But at the point I guess I was trying to make is that in the common law system, this idea of this clear separation really was never there. It's there in spirit, but not there really in the letter of the law. For example, the Attorney General in the UK was, I don't know if it still is, but was a cabinet member. So certainly within the legislature and the executive. So that separation wasn't really that clear. The head of the judiciary, the House of Lords was also a member of the legislature, I think, in the UK. So that system of separation of powers really is quite different. And a lot of the literature on separation of powers is coming from the American model. So that's why I say I'd be a little bit cautious about looking at that. But I think it is necessary. It is an important idea, right, that you have these checks and balances between the three things. And the difficulty is that with the public prosecutor or the attorney general, the question is, where does this person sit, and how is this person going to be held accountable? Now, in Singapore, under our constitution, the attorney general is clearly a member of the executive. So he is a member of the executive. So the public prosecutor is clearly a member of the executive. But the public prosecutor, or the attorney general acting as public prosecutor, is meant to be independent. It creates a difficulty because you've got the one person wearing the two hats, right? As the Attorney General, you are the government's legal advisor. You do what the government tells you to do. As the public prosecutor, you're meant to act independently. And in fact, there was a recent decision where I think, with respect, the court confused these two roles. I'm just trying to think. I think it was one of these drug trafficking cases. Where the Singapore case, a recent case, a High Court decision, where the question was whether the public prosecutor had certain powers, and the court refers to Article 35(8), which is the prosecutorial power, and then goes on to justify the prosecutor's power by referring to Article 35(6) or 7, which is the Attorney General's powers, which are quite different, right? And so I think that slippage is there, and I think we've seen that error even in a judicial decision. I suspect that case will go up to the Court of Appeal, and we'll see what the Court of Appeal has to say about that. But it is very dangerous when you have a situation where the court is saying that the public prosecutor basically can, in a sense, take instructions or do what the government wants it to do, because as the Attorney General, that is his work. Okay, so those two things really need to be kept separate. So that's the separation that we need here in our system between the AG and the public prosecutor.
Alex?
Yes, thanks very much for that presentation. It's really interesting. I'm particularly interested in the concept of discretion that you're using here, because I'm interested, particularly because you use Hart, or a quotation from Hart to illustrate the point. It seems to me that Hart had a much narrower understanding of discretion than the one that you're using here, because for Hart, discretion only arose on the part of judicial decision makers when the rules had run out. And it doesn't seem to me that every instance you're talking about of prosecutorial discretion is one in which the legal rules have run out, and there might be some mileage here to distinguishing prosecutorial discretion in the strict Hartian sense from prosecutorial judgment. And we might be worried about both for different reasons, but exactly how you think these two things relate to the rule of law could dramatically change your understanding of the debate. So just to take, for instance, 377A as an example, if you believe that the rule of law implicates the value of equality, the decision not to prosecute by the public prosecutor in that case, even in a blanket sense, could be an interpretive judgment about what the law really requires. because Section 778 obviously violates any substantively supportable understanding of equality, right? So the decision not to prosecute in every case could be an application of the public prosecutor's understanding of the true legal position in Singapore, such that the argument is simply, well, this is the law on the books, as it were, but it's not the law we're going to enforce because it doesn't reflect the true legal position. Alternatively, if you take a narrower understanding of the rule of law, something more like a Razian understanding, and couple it with that Hartian idea of discretion, you've actually got discretion here in the true sense because you've got extra legal concerns motivating this decision not to prosecute. Whereas, for instance, in circumstances where you're saying, well, there's just not enough evidence, you're just exercising judgment in the application of legal principles that govern you under the ordinary set of circumstances. So I wonder if you could say a little bit more about that and how we might pass a little bit more keenly over that territory.
Okay, so I think in terms of the public prosecutor's decision as an interpretive one, in Singapore, then that wouldn't work simply because the courts have already come up and said, right, that Section 3778 doesn't violate Article 12 because it applies equal. I mean, we can disagree with that, but that is a judicial pronouncement, and it's, as far as that stands, that is the law in Singapore. So in that sense, the prosecutor's decision or discretion not to prosecute, right, is no longer an interpretive one. So I think.
I mean, judges can get the law wrong, but sure. I mean, if we accept that they've got it right, then yeah.
Yeah.
So my reaction to your point, Alex, is that I think there are some decisions, particularly on the question of public interest, where the law has run out.
Yeah.
I mean, there are no rules there, unless there's some government guideline that states very clearly. But generally, when it comes to the decision to prosecute, and at the second step, public interest, it's just a list of considerations. There really is no clear rules. I would say that is discretion.
That's the point where the discretion comes in, right? Which is why prosecutors are leery about issuing blanket prohibitions.
No, and I absolutely agree with that distinction. I think that's a really good example. But my point is rather that these two exercises seem to be different in kind, such as that subsuming them all under the category of discretion seems to muddy the water a little bit.
That's a fair point. Yeah. So let me take that on board. Thank you.
Other questions or comments, James?
Yeah, so I just have a question about how you're defining independence here. I'm wondering if sort of a facade, right? I mean, if you're just saying, well, they're one person with two hats. I mean, can you really talk about independence? If you have a situation where the office of the prosecutor actually is a separate person, then who's doing the hiring? Who's doing the extension of the contracts? Right? I mean, to say that there's independence in that context, if it's the government doing the hiring and extensions, right, the quality of independence is really not there. If you look at the US model, which is actually sort of independent, where you have election of prosecutors, right, that's super independent, but you have a whole host of problems that come from that. Look at the campaigns for these prosecutors on YouTube. You can find so many videos. So I'm just wondering if you can really even talk about independence in the context of prosecutors.
Well, I mean, would you say the judges are not independent because they are appointed?
Well, if they have tenure, life appointment, or
Sure. Well, that's the same with the Attorney General, for example, right? Well, although in Singapore that has changed now, the Attorney General is meant to have tenure. But although that's a problem because in Singapore it's now based on a contract, and there's a retirement age. But I don't think that to have independence, you must necessarily come to that position independently, because you can always be appointed by government, but have your own independence, and that the system must be able to allow for that. So in the UK, for example, the Director of Public Prosecutions is independent, except for certain types of offences where the state has an interest, and that's when the Attorney General exercises supervisory jurisdiction. But until it hits that level, the AG simply will not interfere, whether they like it or not. So you have to rely on that kind of idea that there is independence. Now, if you're talking about a system that you fear may be corrupted, then you start to have a problem, because in terms of, okay, well, you start to appoint people that you like, and but that's a whole different issue, right? But as a system itself, I don't think that independence is incompatible with appointments. I don't think you need to have a situation where the person has to be elected by the people to guarantee independence, because as you say, that raises a whole lot of other much more difficult and unsavory problems.
So we've had this debate in Hong Kong about whether the DPP should be independent because of what the basic law says.
Right.
So we have a basic law provision, I think it's 63, which says prosecution should be free from interference, political interference. And so some people have read that to mean that maybe our DPP should be independent. I haven't felt that that's a helpful way of thinking about it. Instead, I actually prefer the Canadian approach, which is not so much independence and what that means, but greater accountability and transparency in decision making, plus a separation of persons. So when the federal prosecutors in Canada, when they separated from the Department of Justice and they created their own public prosecution services, the legislative scheme creates this office of the public prosecutor, who has tenure as independent. But the Attorney General can still intervene. But when there is intervention, it has to be explicit, and Parliament has to know about it, so that politicians can ask about it. So actually, every time there are instructions given to the Director of Public Prosecution, it has to be put on sort of record, and there has to be a record. I think that's a better scheme. Complete independence may not be a good thing either.
Well, I think that is pretty much the scheme in the UK as well, right? Where they can intervene. But I think at the lower level stuff, right, it doesn't involve, in a sense, national interest matters. There should be pretty much independence. Why should the state be interfering? As long as you have a system that is properly set up, then it should just be left to the Crown Prosecutor or the Public Prosecutor to manage it.
But without transparency, the public just never knows how often the Secretary for Justice calls up the Director of Public Prosecution to do this or that. It's just not. It's not known. Okay, so we've reached our time. I'm going to bring this to a close. I want to thank, firstly, all of you for your good feedback and your attention. But most importantly, I want to thank our speaker, Kumar, for a very enlightening and interesting presentation. All the best in writing that up. Thank you.
Thank you very much. Thank you very much for your comments and for taking the time to be here.
Trial kind of thing.
I think it's got to be scalar, isn't it? Independence, right? I mean, it wouldn't actually total independence implies decision-making.
Which thereby implies
in the absence of information, right? And on the other side, you don't want total dependence. So I think this is Simon's